Hello, everyone. I'm with Mark Quail. I've known Mark for quite, many years, and we've been on panels at MUTEC a few times and talked about different legal things. Mark is a lawyer from Canada, Toronto, I think,
Yep.
precisely, and I think we today what we would like to do is to find ways to support young artists in different legal situations that they're facing. And because of the coaching group that I have, the good part is that a lot of people are getting more and more signed. But the down part is that I'm getting a lot of messages privately about, hey, I'm working with this label and so and so. And people have a lot of questions. So first of all, I would like to do an introduction with you, Mark. Can you tell us more a little bit about your background and the kind of stuff you've done and contracts that you've been working legal wise?
Yeah, sure. And thanks for having me on your this podcast, JP. Yeah, you're right. I'm a lawyer. I'm going on 30 years practice now here. I'm based out of Toronto. My practice is restricted exclusively to music-related work. Some tech stuff, but that tends to be rooted somewhere in music. Whether I'm working with an apps company or any company developing algorithms, they tend to be in the music space. So that's where I get involved. Um, I have been in the past, I've worked for companies like EMI Music Publishing, and I worked at Alliance, the big film and television production company as they then were in the late 90s. And then about 18 years ago, I went off on my own firm, and have been there ever since. So I had good wide experience in the early part of my career, and I've just carried that forward into private practice, acting on behalf of clients. Now, I've represented everybody from heavy metal bands to gospel choirs to film and TV composers. Of late, though, probably starting in the mid 90s, I got more and more involved in the electronic music scene, to a point where now my practice is almost exclusively electronic music artists. And I currently represent people like Richie, Hawtin, Dubfire. Deep Dish has come over as a client. The work that they continue to have. John Aquaviva, Pleasure Craft, Art Department, Mathew, Jonson. I've got a long list of artists that I'm very proud to work with. In the past, I also worked with Juan Atkins and Derek May in the early part of the 90s and the 2000s. Great people, and I'm very happy to work with them too, because to have been able to work with people who invented a genre of music, to me is incredibly gratifying, and I was certainly happy to help them out and keep their business affairs in line to make sure that they were protected. So yeah, my daily work now is negotiating contracts on behalf of artists or small record companies, whoever gets to me first. I run a music publishing company as well, with in conjunction with John Aquaviva. We handle about 6,500 musical compositions, only electronic music. We represent artists and catalogs in that space and make sure that they get their royalties from around the world. And I also work kind of a partner. Anything I get involved in, I tend to be the business affairs legal guy. I play that role in a management company called Sound Mind, where our main focus is a client called Simon Doty, working in the kind of melodic techno progressive house sphere, having just had a release on Anjuna Deep. So we're working hard to get Simon and his career moving in a good direction.
So with that CV in mind, I think people will be fairly confident that you will have some proper answers for the questions I have for you today.
Good.
So, like I said, I work with this pool of people, mostly compared to the people they've been working on with. Sorry, these people are pretty young, inexperienced in terms of business, the world of business, of music business, should I say? And they are starting. They're making music, and some of them are making really good music. And the problem is it takes a little bit of time to find the right place So there's a lot of insecurity for them. Can you tell us more about what kind of things an artist should be checking as a red flag when they are approached by a small label? We have to keep in mind that a lot of these labels that are approaching young artists are most of the time very, very small labels that have like only a few releases either on digital or vinyl. And of course, they want to grow, they want to expand, they want to have great music. But what are the red flags people should be looking at?
Well, I'll give you both red flags and white flags, like things you should look for, because it's finding the right labels. And I say plural there because I think the strategy these days is not to tie yourself in with one label necessarily, but maybe 2 or 3 labels that release on a regular basis. The first thing I recommend an artist look for in a label, and we'll get into some of the nitty gritties in a moment, but the main thing is, how good is that label's social media promotion? Labels today are not about distribution per se. It's very easy to get digital distribution. There's loads of aggregators that can do the job and get your tracks onto Beatport, iTunes, Spotify, etc. What you need is a team, and it is a team sport, is a team that can promote your tracks and your release via social media as effectively as possible. Getting the word out is all important. Without that, your music just dies on the vine. It gets released, it's out there, and it doesn't move because it's not being promoted to the right playlist, or it's not getting promoted in the right way. So the first thing I would look for as an artist, and the first things I would ask is, what social media promotion plans are available through that label? Like, what's their general modus operandi in getting the word out on a track? Obviously, the bigger labels have things like a party series that acts as an adjunct to what they do, and that helps promote the music. Some may even have their own fairly well subscribed playlists on Spotify. Those are other things I would look for. So the first thing I would look for is the social media promotion. Then let's take a step back, and I would look at the contract itself. Small labels should only sign you on a track-by-track basis. They shouldn't walk in and say, okay, we're going to put out this first EP, and now we're going to ask for 3 further EPs from you, and we want your services on an exclusive basis in the interim, which is going to restrict your ability to release on other labels. I don't think that's a prudent strategy. If you have a good working relationship with the label, if the label's doing a good job and the tracks do well, I find more often than not, the artist will always come back to the label and offer tracks, further tracks. I don't think the label needs to tie an artist in that respect. If the parties work well together, then more often than not, the relationship continues on its own because it's a good business relationship. Everybody's getting something out of it. The moment you start tying an artist into in with further delivery obligations, further requirements for tracks, things tend to get, I think that sometimes builds false expectations. And when those expectations are not met, then there's some resentment begins to develop. And I don't think that's a good attitude or good way a relationship between a label and an artist should work. So that I would be looking for what tracks that artist is required to deliver to the artist, or to the label, sorry. Royalty rates, they come into play. You know, what the actual back end is going to be, what the artist is going to be charged for. I think it's, depending on the royalty rate, a good move to split the cost between the label and the artist. In this day and age, getting an advance, which is basically a prepayment of royalties, is very rare. Maybe the bigger labels will pay you, you know, 500 euros for your tracks. It's very rare these days, given the amount of money that needs to be spent on social media promotion and things. That is the main investment that the label will look at, and therefore for smaller labels you don't see advances that often. So why don't I leave it at that, and we'll carry on with the questions. I'll probably come back to some of those points and more points as you kind of draw the scenario out with your questions.
I don't think you're going to be surprised by what I'm going to say, but right now in the underground scene, like maybe way more underground than what you're explaining, is that labels approach an artist and they get a track and then they release it. There's basically no contracts. Mm-hmm. Rarely any emails stating any engagement of what the label is going to give in return. Mm-hmm. There's no explanation about the shares of royalties. And of course, everything is kind of a little bit vague. So mm-hmm. It's basically the person will say yes, give the masters to the label, and the label will put it out. And, like the frequent scenario that I hear about is people a few weeks later or a month later, they'll see their track online on stores. They'll be excited about it, but the communication with the label is a bit kind of like vague and not so clear. And, like most of the time people never get paid, which is kind of a classic. But, for them, it's good because it gives them like a step in the business, and then other labels get to see them. And, so they're not so resentful. They kind of, we call that the sacrifice of virgin, kind mm-hmm. of scenario. But it's still, years down the road, people are looking back and, some tracks they did were actually really cool. And now they're looking at it and they realize that they have no measure, or they have no rights, or they don't know what's happening. Mm-hmm. So how should people approach the underground scene way of doing?
All right. Well, the good thing there is that if you've just given a track to a label and they put it out, if there is no written contract, there's no deal. And in fact, that's actually quite bad for the label, because the artist could simply take that track back and go to another label. In fact, the artist is still in the driver's seat in that situation, and they could do whatever they want with that track. One of the things the Copyright Act in Canada and the Copyright Act in the United States requires this as well, is that if copyright is going to be transferred, it requires a document in writing attesting to that transfer. So if there's no written contract, no meeting of the minds where the parties agree in writing, executed with signature, that this label now has the authority to exploit that copyright, there's no transfer. So if that was the case, if it was in a situation like that, then a few years later, if the artist decides they want to do something further, they can do it. So it's really, it's up to the label really to get could be a 1-page contract, could be a 7-page contract that has more answers to questions that might come up down the road. But it really serves the label to get something done in writing, and then the artist can look at it and see what the royalty terms are and understand exactly what the label is permitted to do. Yes, I understand where artists are coming from. If they get any label excited enough to release their music, yeah, that feels great, and they jump at the chance by and large. But if they remember that they're going to need to sign something that will ideally serve them and get them to ask the label for some further terms, so that everybody understands what the deal is.
So if a label, I mean, that's good news. I didn't even know that myself, so I'm kind of happy to hear about that. Is it true that an email exchange could do the same thing as a contract, or do we really need a contract?
The Copyright Act says you need a transfer documented in writing. Now, if somebody wanted to go to court and put together a series of email correspondences, and if it could be shown that there was a meeting of the minds there, and if something could be alleged to be a digital signature, there may be a case. Off the top of my head, I can't point to anything that would give you a definite answer on that. But that's going to require you go to court to prove that. That's going to require lawyers getting involved in a negotiation, which is going to be prohibitively expensive, and ultimately will, on the value of any one track, generally, I would say that 90% of tracks won't earn enough money to even cover the cost to hire professionals to argue that one out. 99 times out of 100, I see situations like that simply die on the vine. Somebody realizes that, okay, I've got no case here. There's nothing I can base this on. There were some emails back and forth, but there's really not enough to say, I grant you all right, title, and interest in and to all rights to the song, including the copyright, all the kind of magic words that one must see in such a transfer. Even if it was in email format, it's going to be very difficult to kind of show that it meets the standard required for such transfers.
So it's kind of like, the law is on the artist side and it's useful, but for our underground artists, it's kind of irrelevant, since most of the time people could make around $500 to maximum $3,000 for a sale of a track over a few years, if they're lucky enough. So, there's nothing really much that the artist can do besides maybe just point out the label on social media. Is that correct?
Well, if there was an issue in getting their track back, you mean?
Or getting paid.
Yeah, social media would be one outlet. The other, if you're not getting paid and there's nobody responding to your request for an accounting, or your statements are spotty and they don't show you the right information. If you haven't signed anything, take your track and go somewhere else. You may be met with some pushback by the label, but they've got nothing to prove that they own the track. So if you're issuing takedown notices and you're taking the track elsewhere, you're within your rights to do it. Any other label may, however, look at that track and go, well, okay, it's already out there and there's going to be double claims on that track. It's going to get a little messy. Maybe we prefer not to take that track. So while the artist, I believe, is going to be in the driver's seat in respect of the rights that they still maintain in that track, I'd perhaps suggest that the more practical thing to do is go in to any of these deals with your eyes open, look for a contract, and make sure there's a clear understanding about what's supposed to happen. It also serves the artist not to sign any more than one or two tracks in your early situations. If you end up signing a deal with a longer obligation and the terms aren't quite to your liking, or this label drops the ball on a regular basis and they mess up the releases, etc., then you're not tied in any further than you need to be in those situations. You can get out. You can go to another label. Your discography will show early releases on a few small labels while you build up some presence and some experience, and your productions get better so that you end up on labels that are, as I say, further up the food chain. So probably the best strategy I could offer there is that don't sign anything that's going to require more than an EP worth of tracks to a label, and look for some modicum of professionalism within the label. Maybe talk to other labels. If you've never dealt with this label before, talk to other artists on the label and see what they may say. There are no dumb questions in this business. So if you get out there and ask the opinion of a few people, it may help guide you in deciding whether to jump into bed with that label in the first place.
Okay, that's super informative. Lastly, on that topic, um, sometimes people are saying, okay, I sign exclusively for vinyl, and the record is a hit. They repress, and then they repress again, and the label cashes in on that. Of course, no contract, and then the label puts it on digital again, and then the artist gets upset and be like, hey, we agreed vinyl only, and not only you're not paying me for the vinyl, but you're also doing digital. Would the artist be able to, if there's no contract, could he contact Beatport and tell them to put down the song, to not sell it, for instance?
Yes. At that point, because unless the transfer is in writing, unless there's a deal in writing, the label's got no rights. They may have vinyl rights, but they don't have any other rights to exploit that track. So if Beatport at that point was to receive a notice under the Digital Millennium Copyright Act, the DMCA, requiring that Beatport take down that track, Beatport is going to go to the label and they say, okay, we've got this DMCA notice. Can is there a rebuttal from your side? You want to provide us with a contract? Beatport doesn't always do that, but if they were to get in the middle of it, this is what would happen. Then the label's not going to be able to supply a contract because there is nothing in writing that would show Beatport has the right to exploit that track digitally. So that could be a recourse. Another recourse would be to get a lawyer letter written to the label saying cease and desist from doing this. You've got no rights. Those would be probably the two main things that would be readily available to the artist in that situation.
Okay, great. That's good to know. Let's change topic. Now I'm going to put myself in the other seat, which is I am a label owner. Although you gave a lot of really great insights about the things to look at, but as a label owner, I want to start my own label. Legally speaking, what should I bulletproof myself with, or where should I get my templates for my contracts, and what are the things that maybe I should look into at first?
Well, the first thing, if you're setting yourself up as a label, well, there's not a first thing. There's several first things. Obviously, what I recommend is that the label get at least their first 5 or 6 EPs in line. You've got to release on a regular basis. That strategy, the way the algorithms work on YouTube and just generally Instagram, anywhere where you're going to be promoting releases, you need to have regular communications with your audience. So you need to have your first half dozen releases ready to go right from the beginning. And then as you release those, ideally you're signing more tracks and getting more things in so that your release schedule can be frequent but not overwhelming on the audience. So in order to get those releases in and ready for release, you need a contract, and you should go to an entertainment lawyer knowledgeable in the music business who can draft you something that will serve a couple of purposes. Number one, it will secure the rights you need. Do it in language that is clear and understandable so that both parties can fully kind of get what the transaction is about. Because 9 times out of 10, these junior artists are not going to be taking it to a lawyer. They're going to sign what you put in front of them. In many cases, a lot of small labels run on a one-page, what's called in the business a heads of agreement. It acts as a contract, but it's a very short form distilled contract that will set out, what the royalty rate is, how long the track is going to be controlled by the label, etc. So without getting too much further into the nitty-gritty there, the idea is that you've got a written contract that can be presented to artists that will secure the rights in and for the label. Obviously, the label should have a good pipeline of social media plans, a presence on Facebook, Instagram, whatever other tools work for your audience. In some cases, Snapchat might work for your particular audience. In other cases, in other genres, probably not. And you've got to look at what social media really will hit home for your target audience. Not everything's the same. I mean, Twitter, probably useless in the electronic music world. It's become a political thing, not so much a music entertainment thing. I know a few artists are still on Twitter, but I don't think they get much traction, quite frankly. It's probably your first bets are probably Instagram and Facebook. So you want to have a strategy that will be workable, affordable, and wide-reaching in order to get the words out about the track. Because your job as a label, just to recap on that, really is as a promotion vehicle. If you're really good at promotion, your tracks are going to get in front of people, and they're going to stream and or sell, download. So that's got to be the focus. One of the other things that a label needs to ask itself in North America is, do you want to pick up a piece of the publishing? Because 9 times out of 10, that new artist that you're signing doesn't have a publishing deal. That money is going to sit out there and nobody's going to collect it. And if you're a label, you probably have some smarts in the administration world. Ideally, you're already setting yourself up as an organization that can exploit copyrights. The song copyright is different than the record copyright. And that song is going to earn money, and that money needs to be collected, and it needs to be paid to the songwriter, the artist. So labels can often be in a good position to handle that. They can get a publishing and admin deal for their catalog. That will allow the money to flow through the system and ideally get back to the artist. Labels in Europe tend not to pick up the publishing. They kind of see that as something separate. Some do, some don't. More North American labels make it a habit to acquire the publishing as well. It helps get, by having both sets of rights, the rights in the record and the rights in the song under one roof, it makes it easier to get synchronization licenses for film and TV and video game usages, because you're at that point, you're now a one-stop shop. The music supervisor working for those productions can get both sets of rights from you done off in one deal, and it's less work for them. So having those rights in hand is a more attractive proposition for the music supervisors working in that field. So, and just generally from personal experience, I can tell you that artists tend to leave that money on the table, the music publishing money. And with the labels that I've run and do run, just being able to account to them means more money in their pocket. You know, we've gone out, we've collected the money, and we pay their share to them twice a year. So it's something that the label needs to ask itself. Should we do this? Can we do this? And plan accordingly. The third and final thing is the neighboring rights royalties. Those are the performance royalties in the sound recording, not the song. In this case, the sound recording. 50% goes to the artist as performer. 50% goes to the label as the owner of the master. So the other thing you've got to do as a label is get yourself registered with the local neighboring rights society. In Canada, that's Connect Music. And that will provide the label with another stream of income as their sound recordings are performed wherever they may be, on the radio or streaming, etc. The artist should know also that they are entitled to 50% of that, but they don't get their share from the label. They go and join their own neighboring rights organizations. In Canada, there's 2 of them, RACS and MCON. MROC, and those 2 organizations represent the performer artists. You register your recordings with them, and they'll pay you directly. The label doesn't need to share their money from neighboring rights with the artist most times, and the artist does not need to give anything to the label. They get paid separately. They keep their money. It's a stream of income that's not readily known about. I'm surprised how many people don't know that this exists, but it has existed since 1997, and the admin systems are getting better and better at collecting and paying. So those three main things, the neighboring rights, the publishing, and then contracts and tied in with social media, are probably that's the first group of things a label should be looking at when getting organized.
Would you say that even those details would apply to underground artists and labels?
Absolutely. Yeah, because the underground has got a substantial fan base out there internationally. There are, the playlists stream on Spotify. Those downloads sell off Beatport. To lesser extent, the other sources, TrackSource and iTunes as well. They're all out there. All of these, think of the music business as a business of pennies, and you collect those pennies up and turn them into dollars. That's the same thing with every element here. A small, like when you're in the underground, the checks are small, but they add up to something at the end of the year if you're diligent about collecting and registering and staying on top of your business. Initially, you probably won't make a living, but maybe there's enough out there if you've had a little bit of success to buy more gear, something that can go back towards your career. If you don't look after that and you leave it on the table, it gets paid out into what we call the black box. And the money goes elsewhere, in other words, and instead of ending up in your pocket where it should, it ends up in somebody else's pocket. So my recommendation, obviously, being a businessman / lawyer, is to go and collect what you are entitled to and use that money to further your career.
Really interesting. I wasn't planning to do that, but I feel like the publishing is something really misunderstood by a lot of artists.
Mm-hmm.
Even myself, I've been in the business for quite a while, and it's still a little bit unclear for me. But I think maybe this is another topic that we should talk about another time, because I see time is flying, and I have one last thing that I would like to talk with you, which is sampling.
Okay.
Sampling is, as you know, it's not new to electronic music. I guess it's one of the reasons why electronic music became really important, just like hip hop. It's because people are sampling a bunch of things. If we think about classic tracks by The Orb in the early 90s and Daft Punk, sampling old disco and rearranging it completely. It's been there and it will always be there. And in the last few years, one thing that I've seen is the reminiscence of a lot of people sampling music from the 90s, techno music or house music, and kind of rearranging it, but sometimes not super, it's clear that it's the same track, but it's rearranged a little bit, and it's So what are the extent of such practice that people can do? Because I also see a lot of edits. People are editing tracks from The Doors or Billie Eilish, and to name a few. So what are the extent of such practice that people can do?
Okay. Practically speaking, yes, the internet is littered with unauthorized tracks full of uncleared samples. It's the nature of our current artistic world. Call it remix culture, call it what you want. It's easy to do with modern technology, and it happens. Now, if somebody's looking to commercially exploit that track, let's say the remix or the re-edit is so good that other people want to hear it, it does well at gigs and festivals, etc., and you want to commercially exploit that track, you need to clear the sample. You need to go to the owner of the record and or the song and get permission to use that in a new composition. That's called a sample clearance. A little bit of research needs to go in because you've got to find the right owners, the proper record company, the right music publisher. And just the reason I say that is because there are at least a minimum of 2 copyrights embodied in these in any sample. One is in the master and the other is in the song. So and just on that, I can probably summarize that super briefly. When you compose, you're at your digital audio workstation and you are composing your music and you are recording it at the same time, which is generally how it happens in the electronic music world, you're creating two copyrights, one in the song and one in the record. Let's take Derek May's Strings of Life, for example. Okay, so that gets composed in and around 87, 88. If somebody redoes that song today, Derek and Mike James have already written that song. Now, if you re-record it, you own the recording. You've done a complete hands-on rendition of Strings of Life. You've replayed everything. You own the recording. But Derek May and Mike James still own that song, and they will collect the music publishing associated, the royalties associated with the use of that song. So if you're in the studio and you're creating a new track and you're composing, you're essentially doing two things. You're creating the copyright in a master and the copyright in a song. If somebody wanted to sample that, they've got to go to your publisher and your record company and get a clearance, a permission to be able to use that whatever slice you took in your own new composition and have permission to use that. That's a whole kind of the kind of details of what might appear in a sampling agreement could be a topic for another day. The bottom line I think that's important here is that it's a permission granted by the owners to a new user, giving them permission to use it. There may be discussion of a royalty. You may agree on terms that the sampled song will own or form a piece of the new song, and that original publisher gets a 50% or a 30% ownership in your new song. That's generally how it proceeds. If you don't get it cleared, the way Content ID works these days, and it's getting better and better, it can identify snippets and pieces in these songs. If you don't get it cleared, you're going to run the risk of having it taken down. You might get a DMC notice against your video on YouTube. Beatport might receive such a request, and they're going to have to, in most cases, take it down. So you've done all this work. You've done a brilliant track. You've promoted it on social media. Maybe you spent money on artwork and mastering, and now you can't do anything with it because the powers that be that own the copyright are telling you to take it down. Kind of fruitless endeavor. And I therefore recommend any client asking this, if it's going to have a commercial life, if you want this to be a real release on your label, find a way to get it cleared. Couple of points. The bigger the sample, the more expensive it's going to be. If you're sampling a very popular track or a bass line or something that's well known, it's going to be, it's going to be expensive. It could be a couple of grand minimum just to get the record company to look at it. The publisher, more often than not, may not want an advance, but they'll want a piece of the copyright. It's a lot simpler to do that deal, but it's something that you better recognize. One other thing I'll say on this, I've often heard people come to me and they say, well, what is this 1 bar rule or 4 bar rule or 4-second rule? And I know where they're going with that. They've heard that if you take a small slice of a song that you will not have to, get a permission for the sampling coverage. There is no such rule. If you took something super small and it's still recognizable, the person that owns that recognizable slice has still got a claim against you. If in the 90s there was and I won't name the artist, but you know who I'm talking about, there was somebody who was extremely adept at basically micro sampling, and the brilliance in this composer's compositions was that he took extremely small slices and built them up into wonderful rhythms. Well, technically he should get that cleared. Also, technically, nobody's going to be able to recognize where those bits and pieces came from, because you might recognize it for what it is, but you'll really never, at the end of the day, be able to identify it clearly. You could tell it was a sample, but you couldn't tell where the sample was from. It's a very hard thing to do, and that was the genius of that particular composer. So if people throw that example at me, I'd say, yeah, okay, but they're the circumstances. Most times, the other 99 times out of 100, the sample can be identified, and it's getting easier and easier to identify things with, like I say, with Content ID. So bottom line, clear it if you think it is going to be a commercially successful, even moderately commercially successful track for you. Or strategy number 2 would be, don't lift the sample from the record, replay the sample. Then you've only got to clear the song sample. You've only got to go to the music publisher because you did not use anything from the original recording. You replayed it. There's some other issues that one has to get into, and as a lawyer, I'd be saying, okay, watch out for a few other things, but for the purposes of this discussion, I'll leave it at that. Clear the sample.
So, like a lot of people will tell you, well, I just want to do promotion, and what I'm going to do is I'm going to take a track by Billie Eilish. I'm going to do edit, and then I'm going to put it for free download from my SoundCloud. Is that risky?
Well, risky in that, yeah, technically somebody could come, like Billie Eilish's team could come back at you and say, you violated our copyright. And there does not have to be economic damage in such a situation. In copyright law, there's such a thing as statutory damages, which are basically automatic damages, which can range in the U.S. upwards of $50,000 per infringement. In Canada, sorry, off the top of my head, I can't remember what the statutory damages are, but it's substantial. It's not as high as the U.S., but it's substantial. Technically, you could be on the hook for that. Now, practically speaking, that doesn't happen as much as you'd think, because these tracks, they have a lifespan of a few weeks and then they're gone. And if Billie Eilish's team was to chase down every single remixer that was dropping a track with a sample from her, they'd be busy, and it would be a kind of expensive exercise to chase these people down, and it might not earn them any money. If it was a track that was blowing up, what I've seen is that the label then goes to the remixer and it says, look, why don't we license this from you? Rather than shut you down, why don't we take this from you and let's turn it into a legitimate remix? Because we've seen that, the kind of proof is in the pudding approach. They've seen that this track is getting great traction. It's a good remix. It serves the artist's identity, it works for the audience, etc. So let's make it a legitimate remix and pay you a fee, and then we can go and exploit this thing and make some real money off it. The publisher would be happy with that. The record company ends up being happy, and the artist, the remixer, gets a boost in their career, because then they get known as being, oh yeah, that was the person that did that crazy Billie Eilish remix. And
yeah,
I'm sure you can probably know lots of examples like that, as can I. You see these artists get a start coming out of the underground.
I'm always really careful to tell people to do that, because although this, as you say, could happen, it's extremely rare and really, really rare. And usually there's like kind of ties between the artist and the original artist that can kind of like favor this remix to be eventually be published by the original artist. But it's, again, it's super rare.
Yep.
So I would like to know, like you're talking about the risk about putting it on SoundCloud. I've seen some people go a little bit further and sell it on Bandcamp, and, selling quite a lot with, really recognizable samples. And people are like, oh, he's getting away with it, and I can do the same. And Bandcamp doesn't seem to be reacting so much. What are the risks there? Is it more than SoundCloud, or is it less, or how can the person can get away with that?
Well, it's the same, because no matter the method of exploitation, if you're violating somebody's copyright, you are doing something that that has not been sanctioned by the statute, and that owner has rights. So whether no matter the forum that it appears on, that's now an infringement. And if the track blew up and made lots of money, there's going to be a bigger discussion as to how much profit the sampling artist is going to have to pay the sampled artist. And again, each such violation could be subject to the statutory damages that are specified in the statute. And those, to describe those for a minute, those are basically that's an automatic penalty assessed because you were found to do something wrong. And the other side the sampled party doesn't have to prove that they lost a ton of money. The act says, no, this is the penalty for your violation. And if the judge in the court decides that, yeah, this meets all the parameters, we're going to assess statutory damages. That's a big kind of penalty that the sampled artist is going to have to pay. So those are the risks. Bandcamp would be subject to a DMCA notice or a notice and notice under the Canadian system. It doesn't quite have the same teeth that the US system does. At the end of the day, again, the track could be taken down. I am sure that Bandcamp's terms of service with any of their clients contain a representation and warranty that says that that says that you own all the rights to these tracks, and if you don't and we get into trouble, you're going to cover our legal expenses. So yes, the sampled artists could find themselves not only having to pay a penalty to the artist that they sampled, but also to all the forums that they used in distributing that track, because now they're on the hook because they agreed to the terms of service, or maybe it's embodied in a distribution agreement. It's going to be somewhere. They're going to have to, fork over to that forum as well. So there are dangers there, and one must proceed with caution. And obviously, as a lawyer, I say, look, just keep yourself out of trouble in the first place. Clear the sample. Now, I recognize that this goes on and it's commonplace, and I'm not naive that it happens, but at the same time, I'm telling the artist, don't be naive in thinking that you could get off this scot-free. There may be penalties.
Okay. Well, thank you so much, Mark. It's been, I've learned today.
I'm glad to be here. Glad to help out.
Yeah, and I'm sure there's a lot of people that will be learning from the advices that you've provided for us today. So on behalf of everyone, I want to thank you, and we'll be hopefully talking again soon, because I think that there's a lot of topic there that maybe we could expand one day.
All right.
Thank you for your time. I'm going to stop the recording, and